Good afternoon and welcome to the final round of the HNBA's Ubaldo Herrera National Moot Court Competition. This competition this year is particularly special to all of us because it is our 30th annual. And every year that we're able to host this competition is a year that we honor and we honor the legacy of Ubaldo Herrera. And for those of you who don't know the story, Ubaldo Herrera came to this country at the age of 11. His family brought him, as many of us have experienced similar situations. He came here only speaking Spanish. He mastered the language of English. He went to law school, became a very prominent lawyer, and became one of the founding members of this competition. We lost him way too early. He died of cancer, and the board unanimously voted to name this competition after him. And so it is our honor to carry on his legacy here on our 30th year of the competition. The two teams that are competing here today, I can't tell you where they're from, but I can tell you that they were part of the initial 24 teams that started in this competition. They have now competed through 2 preliminaries, a quarterfinal, a semifinal, and through all that, they've been able to beat out all the competition, and so they're both here to compete today against each other for the title of National Moot Court winner. Before we begin today, I just want to explain to you how the round is going to work. We're going to have a petitioner and a respondent. They will be broken up into 25 minutes each side, with the petitioner being able to reserve time for rebuttal. Before we begin the moot court competition today, I do want to introduce our very esteemed panel, beginning with our chief judge. This is going to be Judge Stephen D. Grimberg. He's right here in this courthouse, the Northern District of Georgia Federal Courthouse. And then we've got Justice Verda Colvin from the Georgia Supreme Court, and also Justice Charles Bethel from the Georgia Supreme Court. Again, a very esteemed panel. I want to thank the HNBA, I want to thank VIA, I want to thank our president-elect, all of you for participating. We couldn't do this without you. To the judges who come here every year after year, to our DSB, to Judge Castro, my partner, who I could never do this without, to all our volunteer bailiffs and law students, thank you so much for being a part of this. I wish all of you the best of luck today, and we hope to see all of you next year.
All right. Thank you very much, Judge.
All rise. The Supreme Court of the United States is now in session. Justice Grimberg, Justice Colvin, and Justice Bethel presiding.
Good afternoon. You may be seated. All right. Well, with introductions already out of the way from the bench, I'm going to call the case. This is the matter of Linwood et al. V. Aaron Salazar, the Attorney General for the state of Hamilton. Let's have appearances of counsel, beginning with the petitioners.
Good afternoon, Your Honor. Valeria Corral, and I'll be arguing issue 1 for petitioners.
Good afternoon. Jamie Flores, arguing issue 2.
Thank you.
Thank you.
And for the respondents?
Good afternoon, Your Honor. Victoria Pinapar, counsel for respondent, arguing issue 1.
Good afternoon. My name is Andrea Solis-Canto, arguing issue 2 on behalf of the respondent.
All right. Thank you very much. Would the petitioners like to reserve any time for rebuttal?
Yes, Your Honor. 2 minutes, please.
2 minutes? All right. Very well. And you may proceed.
Chief Justice, Your Honors, good afternoon. May it please the court. My name is Valeria Corral, and I, along with my co-counsel, Ms. Jamie Flores, represent the petitioners, John and Martina Linwood, as parents and next friends of A.L. and Dr. Kathleen Moyer. This court should reverse the 12th Circuit's decision for the following 2 reasons. First, Hamilton Code Section 902.11.103A1, which will be referred to as the statute, is unconstitutional as it violates the Equal Protection Clause of the 14th Amendment. The statute creates a sex classification which does not pass the standards set under heightened scrutiny. Second, the statute violates the Due Process Clause of the 14th Amendment, as parents have a fundamental right to make decisions regarding the care, custody, and control of their children. I will be addressing the first issue, and my co-counsel will address the second. Now turning to the first issue, there are 3 reasons why this court should reverse the 12th Circuit's decision. First, the 12th Circuit erred in not applying the proper 2-step test that is required for equal protection cases. Second, if that test was applied, the lower court would have seen that a sex classification exists, which does not pass the 2-part test that is required for heightened scrutiny. And third, as a matter of policy, children have the right and ability to live freely from dehumanizing legislation.
So how does it violate the sex classification that you mentioned? Because boys and girls are treated the same when they have dysphoria, right?
Your Honor, it's the specific classification between members who are not transgender and do not suffer from gender dysphoria versus members of the community who are cisgender. And I will point this court to the decision made in Bostock versus Clayton County in 2020, where this court said that any discrimination based on sexual orientation or transgender status necessarily entails sex discrimination.
Are you asking us to develop a quasi-suspect class?
No, Your Honor, there's no need to create a new suspect class, and we do acknowledge that this court has stated multiple times that it's not in the business of creating any new suspect classifications, but this is simply expanding on the classification that already exists. And that Bostock decision was only 5 years ago, and we think it creates a good example of how this court views transgender status and believes it falls under the umbrella of being a sex classification, therefore requiring the 2-part test of heightened scrutiny.
Was that the holding, in our opinion, in Bostock?
So that wasn't the holding. Bostock, it was a combination of 3 Title VII cases that had to do with employment discrimination based on sexual orientation and transgender status. But even though that was an employment discrimination case, and what we do have here is an equal protection analysis, we do believe that overarching idea that this court set forth is applicable here, raising this to that second level of scrutiny that this court has applied before.
So you agree we would not be reversing precedent to go the other way?
No, Your Honor, precedent wouldn't be reversed, but it would simply be expanded from what this court has already set forth. This court has already stated that any discrimination between 2 sexes requires the heightened scrutiny test, and that's exactly what the lower court did not do. It did not apply the heightened scrutiny test, and if it was applied, we would see that the Hamilton statute—
Tell me again your construction of how this treats different sexes differently. I understand the argument of you're saying someone who is cisgendered has access to care, but this is really defining a scope of care within the medical profession, and it doesn't seem to just differentiate. It just says this sort of care is not available across the board.
When we look at the sort of care that this statute applies to, and the only exception that it's not made for, it's only gender dysphoria. And when we look at what gender dysphoria is equivalent to, that is the transgender minor community here. And the specific differences and classifications that are made is that a minor living in the state of Hamilton who's female or minor is able to go to their doctor's office and get that respective hormone for whatever sex they identified. But here, on the other hand, a transgender minor living in the state of Hamilton is not able to go to their doctor's office and ask for the same hormones. And the Hamilton legislature bases this decision on potential medical risk that could be associated with a minor receiving that opposite hormone within their body.
So isn't that a sufficient enough basis for the state to enact this statute?
No, Your Honor, because when we look at what happens to the potential side effects that respondents here allege, those same side effects are applicable for a female who receives too much estrogen or a minor who received too much testosterone.
Well, but to my colleague Justice Colvin's point, once we're looking and evaluating side effects, aren't we getting dangerously close to making a legislative decision?
No, I don't believe so, Your Honor, because here the statute is based on these findings and the medical data that comes along with it.
Well, to the Chief's point, I mean, if we're talking about medical data, we're almost decidedly talking about a policy decision, which seems like a legislative decision, right?
I don't think that this is only a medical policy argument. It's the fact that a differentiation is being made for one subsect group that is okay for another subset group, and they're basing those decisions on medical side effects that are applicable in both situations. Here, when we're looking at the two-part test that is required for heightened scrutiny, which came out of this court in Craig versus Boren, the court has to set forth an important government objective, and the classification has to be substantially related to the achievement of that objective.
I mean,
Here,
protection of children, I mean, protection of child welfare, I mean, is a pretty substantial government interest, yes? Whether we agree with the policy choices doesn't change whether that's a substantial government interest, right?
I agree that that is a valid government interest, and it's stated at the record here in page 3. Specifically, the Hamilton legislator is concerned with the physical and the emotional well-being of minors. But when we look at what will truly happen if this statute is allowed to be implemented, the opposite effects of that will take place. Studies have shown that in states where anti-transgender laws aimed at minors have been implemented, suicide rates go up by 72%. Studies show that when we allow minors to receive this gender-affirming care—
You're arguing an equal protection claim. What authority do you have for cases where we or any other court have rooted an equal protection analysis based on a perception that the policy choice was a bad one or a wrong one?
I don't have any cases right now to give you. I could provide a substantial brief for you, Your Honor. But what I would say here is the reason that this argument is focused heavily on medical policy is when we look at the brief that was submitted to the lower court and the findings that are included at the last half of that brief, there's no medical science or medical data that is pointed to from the respondents. All of that stated as a reason for wanting this legislation to continue to be implemented is to have minors appreciate living in their original sex that was identified at birth. When we look at the specific restrictions that come about having this classification, simply having wanting a minor to live peacefully with the sex that was identified at birth, when we know that's not the case, there's a lot of trauma that comes along with that, mental anguish. There's a clear disconnect between what the Hamilton legislature is intending to enact and the realities that what will happen because of that legislation. And further, when we look at the four-part test that came out of Lying versus Castillo to consider whether there is a classification, this court has looked to whether that subsective group has historically been discriminated against, whether that group has a defining characteristics, whether that characteristic is immutable, and whether that group is a minority within political power. And when we look at all those classifications, all four are met here.
Aren't there others that are met too? I mean, what about mentally disabled people?
Yes, Your Honor, that's also met, but this court has stated previously in its cases that that applies as a rational basis argument. Here, respondents will come up here and say that transgender individuals and transgender minors are have a valid classification that come along with that. And when looking at that four-part test, they meet all four parts, creating a classification.
But to the Chief's point, why should transgender be treated any different than the other classifications that we don't consider being a suspect class?
Because discriminating based on transgender status is discriminating based on sex. Specifically here, we see one subsective group that are able to receive certain benefits from their government and the medical professions in that state because of their sex, and another subsective group that is not able to receive those same benefits because of their sex, and they're living in a way that is inconsistent with that sex.
But isn't this just like the issue in Dobbs, where we just have to acknowledge that there are some sort of biological differences between men and women, boys and girls, and that does not in and of itself create an equal protection issue.
I think the way that this case is different from Dobbs, Chief Justice, is that Dobbs was clearly about the issue of abortion, which only women are able to receive access to. Here we have a medical treatment, gender dysphoria, where a certain subset group of minors are not able to receive that care, while another subset group of minors are able to receive that care.
Well, but that sort of is a matter of altitude, right? When you say that care, it is not care for gender dysphoria for that other subset. No one is allowed to receive care for gender dysphoria. So it's a matter of where I set my point of view, right? I mean, so why is it that it has to be that it's the actual delivery of the care that why is it that granularity that we have to set our lens?
Your Honor, I see that my time has ended. May I very briefly?
You may finish your answer.
Thank you. Do you mind repeating your question, Your Honor?
Yeah, so you're saying for one group can get the care, another group cannot get the care, and my question is why does the lens have to sit at the level of care of, is this a care available? The care, no one can receive gender dysphoria care, correct?
Yes.
So you see the point is why do we have to then say no? We can't look at it as no one can receive gender dysphoria. Some other people can receive care that, if it were given to somebody, would be just gender dysphoria care. You follow what I'm asking?
I apologize. No.
No. So you're saying that an individual who needs more, who is assigned to the sex female, needs more estrogen for normal healthy development, can get the same care as someone who is assigned to the birth male but seeks estrogen for gender dysphoria. Mm-hmm. My question is why is it not so that you would look at that and say neither one of them can get care for gender dysphoria? No one can.
I think the differentiation there is that it is only transgender minors who are suffering from gender dysphoria. So although that cisgender minors might be able to receive other types of care, and of course they wouldn't qualify to receiving gender dysphoria, but that's because that only applies to a subset that is transgender. Therefore, for all these reasons and the reasons my co-counsel will address, we ask this court to reverse the 12th Circuit's decision.
Thank you very much.
Thank you.
Mr. Chief Justice, Your Honors, may it please the court. Good afternoon. My name is Jamie Flores, and as my co-counsel stated, we represent the petitioners, John and Martina Linwood, and Dr. Kathleen Moyer. The Hamilton statute is unconstitutional as it violates the Due Process Clause of the United States. The decision of the 12th Circuit should be reversed for the following 3 reasons. First, the statute infringes on a parent's fundamental right to make decisions regarding the care, custody, and control of their children in violation of the Due Process Clause. Second, the fundamental right to make medical decisions belongs in the hands of parents, not the government. Finally, as a matter of policy, it is important to leave medical decisions in the hands of medical professionals, parents, and children.
Is this the only instance in which the state has ever, excuse the word, but trumped the parents' rights to control the behavior of their children?
No, Your Honor, there have been other instances, and for example, the respondents may come up and argue under Washington versus Glucksberg in our court's history in 1977. There, the state's interest did trump the adults and children's alike's interest. In that situation, the difference was a life and death situation, and similar cases involving life and death situations, such as in cancer treatment and other terminal illnesses, that's where we drew the line where the state could trump that interest because we had an interest in preserving life.
Could this be considered preserving life in that some of the minors end up regretting their decision and it gives them all sorts of mental health issues as a result of going through with this treatment?
We believe that the state may argue that, but science and medical associations overwhelmingly support gender-affirming care and believe that that option should remain. And we believe that that, again, is a parent's right to decide whether that treatment is right or wrong. In this situation, as the dissenting judge in page 18 of the record, he stated, the problem in this case is that the government believes that they can leave this treatment available to adults and other children, specifically heterosexual children, but that same care cannot be given to transgender children, despite the parents believing that is in the best interest of the child. That does counter our court's history and traditions, and we should not allow that to stand. Here, it is completely appropriate to allow parents to make the necessary decision if they believe it is in the best interest of their child. Under Troxell versus Granville in 2000, this court stated that the parents have an interest in the care, custody, and control of their child. And specifically, this court said that it is the oldest of the fundamental liberty interests in this court's history.
Was that an executive decision or a legislative decision in that case?
A legislative decision, Your Honor. The interest, though, what we find from Troxell versus Granville is that this court recognized that parents have that liberty interest, and we believe that is the source of this fundamental right. As other fundamental rights, we do not believe that that right is absolute by any means, and we concede and recognize that the state may have certain circumstances where they can intervene. We do not believe this is one of them.
Give us an idea of one that would be.
Yes, Your Honor, as I suggested earlier, in the situations with life and death situations, we do believe that that is when the state has a...
Who is the proper arbiter of life and death and the severity of the interest when we're talking about a legislative process?
We believe that in those situations, we believe that medical professionals are in the best interest of making that decision and guiding the legislator.
But the Constitution doesn't assign that responsibility to medical professionals. It assigns it to legislators, right?
Yes, Your Honor. In this situation, we believe that the legislator is overstepping their boundaries by attacking parents' fundamental rights. When we look at a substantive due process issue, we must analyze it under a two-part framework, where we ask ourselves, is it part of our nation's history and tradition? And is that part of our order scheme of liberty? In this situation, parental rights have always, if not always, trumped a state's interest because parents are the rightful advocates for their children.
Is it problematic that there is contrary medical evidence that suggests that perhaps this is not the best course? Is that the reason why the state has a valid argument that there should be some intervention on the part of the legislators?
Your Honor, we understand that there may be some, facts that aren't as great for our side, but overwhelmingly, every major medical association, including the American Medical Association, the American Pediatrics Association, and the World Health Organization, believe that gender-affirming care is appropriate. The respondents argue in pages 2 and 3 that these are very invasive procedures, but it could be something as minimal as social transitioning or even just talking to a therapist about how a child is feeling, disconnect with their body. It doesn't have to mean that there are surgical procedures. While that may be an option at some point in the gender-affirming care, that is definitely not step one in the process.
Counseling is treatment as well.
Excuse me, Your Honor?
Is counseling treatment as well?
Yes.
And so would it be your stance that this statute is overly broad?
We don't believe so because this one is simply an all-right ban. As the record suggests in the findings, European countries such as Sweden and Finland have taken a step back and started to look at their gender-affirming care, but they only took a step back to review the guidelines of their criteria of who can receive gender-affirming care. They're not creating an outright ban, such as the Hamilton legislator is attempting to do.
Did they do that through the courts or through the legislative process, those countries?
They went through the legislator and they began looking at the guidelines, Your Honor. This situation, though, when we look at our country's history and tradition, looking back at the case of Wisconsin versus Yoder, this court declared that the primary role of the parents in the upbringing of their children is now established as an American enduring tradition. Under that tradition is where we believe that parents have the fundamental right to make decisions such as to receive gender-affirming care or not. That is where it belongs and not in the hands of the government.
But you acknowledge that the standard that we would be analyzing this under would be different if this was an executive decision rather than a legislative one, correct?
Yes, Your Honor, we do understand that position. We believe that this rightfully belongs in the courts, though, because of our history and tradition of parental rights. We have always allowed parents to be parents up until the time where a legislator, or excuse me, a court can deem a parent unfit.
No, what I'm asking is, would our standard of review be different if this was an executive decision rather than a legislative one?
Yes, Your Honor, we do believe so.
And where in our traditions and history is there a distinction on substantive due process rights between executive decisions and legislative ones?
I'm not sure if I have the proper case to give you, Your Honor, but we will say, because this is rightfully in this court today, we ask this court to once again find in support of parents, as Your Honors have throughout our court's history and tradition. We have to ask ourselves, who is the appropriate person to make a decision? On one side, we have the parents, the children, and the medical professionals asking for gender-affirming care. On the other side, we have legislators who believe they know more, and they rightfully believe that there are risks and harm.
Let me ask you a question. If we allow treatment for gender dysphoria with adults, why not allow it for children whose parents agree that they should have that treatment? What's your best argument in that vein? Because I'm sure your colleagues on the other side will say something different.
Yes, Your Honor. Our belief is exactly that. Under Parham versus JR, this court decided that parents have what a child lacks in experience, maturity, and capacity for making life's difficult decisions. Under that standard, we believe that if this treatment is available to adults and they can sign on to these risks, if a parent, a well-meaning parent who typically, under our standards, makes the best interest or is making decisions in the best interest of the child, then they can rightfully agree or not that gender-affirming care is appropriate.
Counsel, you've referenced life and death, so I won't give you child car seats, but we have mandatory attendance laws for public schools or for schools throughout as far as I know, throughout the United States. Those interfere with the parent's choice about the care, custody, and control, don't they?
Yes, Your Honor, and to that we proffer this. Parents who are vaccine hesitant or known as anti-vaccination parents, the state may regulate vaccines as we concede they can, but parents still ultimately get to decide whether or not to give that vaccine to their child, even if—
On what basis?
Even typically on religious exemptions, but nonetheless, it goes to show that parents are able to make that decision.
But a suspect class, right? A protected class of, we got the handy First Amendment, right?
Yes, of course, Your Honor. And we understand that and firmly understand the difference, but fundamentally, parents are still able to make that decision, even when research and studies show.
But not on the basis that they're parents, or not on the basis of their custody and control, on the basis of religious objection.
Yes, Your Honor, we understand that and concede that, but we believe overwhelmingly our nation's history and tradition has shown that even if parents aren't making the quote-unquote right decision, they are allowed to do so anyway.
So give me your best case for our history and tradition in this country of the courts dictating a scope of medical practice regulation of a state. What's the best example of the courts regulating the scope of medical practice in a given state?
Well, we believe in the situation such as cancer, experimental cancer treatments, those types of treatments have typically not been allowed to be given to patients because they are experimental in nature. So we would argue in that situation, the state can regulate that type of treatment and not allow it.
You see a proliferation of these right-to-try statutes. Legislatures are saying, hey, if you have no other choice, you can do whatever you want. But that's a legislative process. My question is, when have the courts said to a legislature, your ability to regulate scope of medical practice is, we override that?
Yes, Your Honor. I'm not sure I have the proper case showing that the court is telling the state they are overreaching, but we believe this is a good place to start, and we believe that under this court's history and tradition, parents have a fundamental right to make decisions. Again, on one side, we have parents, children, and medical professionals advocating for gender-affirming care and telling us that it is good for the child. And then we have legislators who know nothing. Your Honor, I see my time has expired. May I briefly conclude?
30 seconds.
Thank you. We see on the other side legislators who believe they know best. They don't. Parents do. Therefore, for all these reasons and the reasons stated by my co-counsel, we ask this court to reverse the decision of the 12th Circuit. Thank you.
Thank you very much.
Good afternoon, Your Honors, and may it please the court. My name is Victoria Peña-Parr, and along with my co-counsel, Andrea Solis-Canto, we represent Respondent, the state of Hamilton. Your Honors, the Hamilton legislature has a duty to safeguard minors from under-researched and potentially dangerous medical treatments. Thus, Respondent respectfully requests that this court uphold the lower court's ruling and find that the state was acting within its police power.
Let me ask you, would you say, or in my mind, the statute could be seen as overly broad in that treatment can include counseling? So what says you regarding that?
Your Honor, I would like to actually clarify the record on that count. If we look to the definitions in section 102 of the record, it specifically prohibits 3 types of medical treatments: puberty blockers, hormone therapy, and surgical augmentation. It does not prohibit therapy. So under that framework, it is not over-inclusive, as children may still receive gender-affirming care in other varieties, including therapy from medical practitioners. That being said, the Equal Protection Clause does not prohibit states from reasonably regulating medical care for 2 reasons. First, the mere reference to sex does not automatically classify a state action as a sex-based classification. Here, the appropriate classification is age, and under rational basis review, the statute unquestionably survives. Second, even if this court were to extend the equal protection doctrine beyond its traditional limits, the statute still survives heightened scrutiny, as the state was pursuing a legitimate government interest through substantially related means. Turning to my first point, attempts to apply intermediate scrutiny when a state is regulating pediatric medical care simply because that medical care references sex is misguided. As this court stated in Dobbs, especially within the medical context, because a statute regulates on the not regulates on the basis of sex, because it mentions sex, simply because it's doing so for a practical purpose does not automatically trigger heightened scrutiny. And that's what the statute is doing here. Moreover,
Isn't it more than just mentioning sex? I mean, this is a law that allows boys to obtain testosterone treatment, but not girls. So isn't that on its face a difference on sex?
no, Your Honor, because here the statute is actually taking into consideration the practical effects of medicine and how that applies to your sex assigned at birth. So for example, if you are assigned male at birth, you will inherently have a different reaction to receiving estrogen treatment as opposed to testosterone. And that is more so a practical determination by the legislature that they found through the legislative findings presented to them. That being said, U.S. versus Caroline Products specifically says that the Equal Protection Clause is applied when there's prejudice against insular minorities. Here, there is no prejudice as it is done on practical limitations.
But they are an insular minority, wouldn't you say?
Correct, Your Honor, but the statute is not necessarily targeting them on the fact of their sex or a quasi-suspect classification. Here, the appropriate classification is age, and when we look to the core of the statute, it is regulated on the basis of age. Specifically, the statute says administering the treatment to minors and performing such treatments on minors. This is in section 103 of the record. If this statute was truly on the basis of sex, it would apply to adults and minors alike. Here, that classification is on age because it is setting a minimum age of legal access.
Can it be both? I mean, it doesn't have to be a binary choice, right? It could be age and sex.
Your Honor, the statute could be both, but that's not what the statute is doing today because it's not arbitrarily denying a trans child access to gender-affirming care simply for being a trans child. It is denying them access to care because of the implications it could have on their sex, because of their sex assigned at birth. This is not about who is denied treatment, but more so what treatment is being denied, and that treatment is treatment that has that is specifically under research and has long-lasting effects. If we look to the legislative findings in section 101 of the record, it specifically states that this research is that the research is simply unavailable when the legislature went to seek it from other medical professionals. Other medical research journals state that existing studies are often short-term and biased, with few extending beyond 3 months.
Why allow treatment for precocious puberty but not for gender dysphoria?
Your Honor, allow me to clarify even further. This statute does permit treatment for gender dysphoria. In doing so, by allowing treatments like therapy, a child
But it
is still...
doesn't allow all the treatment that you can get for the puberty.
Yes, Your Honor. Specifically, the legislature made exemptions for precocious puberty, for example, but other exemptions like allowing therapy by not explicitly stating it in the statute. In doing so, the state was actually acting very carefully to narrowly tailor this law and not infringe on sex-based classifications under the Equal Protection Clause or a quasi-suspect classification under the Equal Protection Clause. So the state was actually crafting the legislation very intentionally as so not to infringe on these rights. Under that framework, the statute also doesn't limit outward gender expression, it simply limits medical effects. This court has stated in Murgia, age-based classifications warrant rational basis review, and this statute survives rational basis because first, the legitimate interest is safeguarding minors, and by reasonably tailoring the statute to targeting treatments that are specific, that cause those specific harms, this is more than rationally related.
Well, let me ask you the question I asked your friend on the other side. If we allow this treatment for adults, why is it prohibited for minors whose parents, who are adults, help make the decision regarding the treatment for their minor child?
Your Honor, it's regulated on the basis of age because this is when children are ripe for puberty, and that's when these long-lasting effects are more likely to impact a child. Well, that is when the medical treatment would impact the child. So an adult has already undergone puberty, and they won't have the same practical effects as a minor
But
would.
I guess
Nor-
what
nor
I'm
would
asking
they-
is, since
Nor would they be likely to have similar sort of therapeutic benefit of the care to the extent that it is successful. I mean, it is going to be most successful before the process of puberty is complete, right? I mean, I know that's not your case, but isn't that right?
Yes, Your Honor, that is correct. However, the legislature weighed the harms and benefits of allowing such treatments, which is why they carved out those specific exceptions.
Is puberty the standard in the legislation? Because I thought it was minors, in which case, I mean, you could have a 17-year-old who has already gone through puberty and still be prohibited under this law, correct?
Allow me to clarify, Your Honor. It is on the basis of age, so set by minors. Puberty is simply a rationale as to why the medical treatment would be different for adults versus a minor.
I mean, but also rational, I mean, in terms of rational ways, it's that minority is legally an incapacity, right?
I'm sorry, Your Honor, could you clarify?
Being a minor is a legal incapacity. It's why minors can't contract, it's why minors can't vote, I mean, like, that would be I mean, if we're only living in rational basis, that would be a rational basis, right?
Correct, Your Honor. This is exactly why the legislation is permitted under age-based discrimination, because this is not a new thing for states to regulate on the basis of health for children. So if we look to statutes like tobacco, alcohol, or even enlisting in the military, those are all statutes that were put in place regulating to protect minors. Turning to my second point, even if this court were to expand the equal protection doctrine beyond its traditional jurisprudence, the statute would still survive heightened scrutiny if it was determined to be a sex classification or a quasi-suspect classification.
When is the last time we found something to withstand heightened scrutiny?
Your Honor, there has been several instances under intermediate scrutiny. Specifically,
Heightened scrutiny was my question. When's the last time?
I'm specifically looking to Michael M., which states that the statute does not violate equal protection simply for applying unevenly to the sexes. The key distinction here is when it's done on a practical purpose rather than reflecting invidious discrimination. And that was, I believe, in the 1980s, Your Honor. The test that this court should apply is whether the government must show the classification serves an important governmental interest, and it's done through substantially related means. Here, the important governmental interest is protecting minors of Hamilton from under-researched and potentially dangerous medical treatments. This includes documented risks like sterilization, which undermines the reproductive autonomy of transgender children and people who may later choose to detransition. And the statute itself is substantially related because it only bans specific medical care that is under-researched and has long-lasting effects. Trans youth will inevitably seek out any type of medical care to affirm their gender identity. And what the Hamilton legislature did is they simply narrowed that available medical care to treatments that have already been deemed safe in the eyes of the state.
So the problem is we don't have enough historical data to do anything differently. Does that justify the legislator's decision?
No, Your Honor. The fact that this medical treatment is so novel does play a key role. Here, if the legislature was given new research that provided that the treatment does not harm children as much as the research that was presented to them at the time, it might be a different case, and they can go back and amend the statute. But based on the legislative findings that they were given at the time, it demonstrates how under-researched, how novel, and how potentially dangerous this treatment must be, which gives them the discretion to regulate it on a reasonable manner. They, in fact, cabined it simply to minors because they were concerned with the effects that it could have on them as they're in their upbringing ages. That being said, the statute reasonably regulates medical care for vulnerable trans youth. So in reality, the Hamilton legislature was specifically seeking to protect trans youth. As we know, children are going to be seeking gender-affirming care and doing so in the most, in the quickest way and the quickest avenue possible. So in doing so, they wanted to make sure that the avenues that were available to trans youth were ones that were deemed safe. Under that framework, the statute survives both rational basis review and intermediate scrutiny. Even more so, going to the opposing counsel's points, this does not qualify, well, even if this court were to extend it as a quasi-suspect classification, it has not done so for over 40 years, and doing so would be ill-suited for the facts of this case.
What do you say about the four-factor test that she mentioned? The group is subject to discrimination, have defining characteristics, and group discretely defined by distinguishing characteristics, and minority lacking political power.
Your Honor, it is not our contention that they are not a minority lacking political power, and the Hamilton legislature or the state of Hamilton is sympathetic to those. To that fact, it is our contention here that the more appropriate classification is on the basis of age, so we do not even have to engage in a quasi-suspect analysis. And for the foregoing reasons, we ask that this court uphold the lower court's ruling and find that the state of Hamilton did not violate the Equal Protection Clause. Thank you.
Thank you very much.
Good afternoon, Your Honors. May it please the court. My name is Andrea Solis-Canto, and I represent the respondent, the state of Hamilton. Your Honors, at its core, this case is about a state's responsibility in protecting children when their health and well-being are at stake. While parental rights are deeply important, they are not absolute. By restricting access to under-researched medical treatment, the state of Hamilton has acted within its authority to protect children from significant harm. The Due Process Clause does not grant parents an unfettered right to access pediatric gender-affirming care that has been reasonably banned to protect the health and well-being of minors.
We have always fundamentally given parents rights over their children that are very extensive. So why should we in this instance not do the same? When they're an adult, just like adults who seek this treatment with the knowledge of life and all of that, and recognizing that these are their children. So why shouldn't we give them the ability to make this decision for their children?
Your Honor, because while we agree that parental rights are deeply important and rooted in this nation's history, they are not without limitation. This court's decision in Parham is one that recognized that while parents do have the right to direct their children's medical upbringing, that is not an unfettered right, and rather can be limited, especially in areas of medical uncertainty. But taking a step back before diving into is the court must first determine the asserted fundamental liberty interest at issue in substantive due process cases. After first framing the right at issue, then second, the court will focus on whether that specific right is deeply rooted in this nation's history and tradition. Here, the proper framing of the right at issue is not one that is just focused on parental rights solely, but rather is a parent's right to access reasonably banned pediatric gender-affirming care. This court's decisions in both Glucksberg and Dobbs recognize that in substantive due process cases, rights cannot be framed broadly or generally. Rather, they must be narrowly framed with specificity that can either be rooted in the statute itself or as narrow as the medical treatment itself. Access to specific medical procedures do not constitute a fundamental right, as this court has decided in those cases. In framing this right as narrow as pediatric gender-affirming care, both following the treatment itself, but also the language of the statute, ensures that parental rights are not broadly overridden by this court's decision because it is a narrow framing that follows this court's precedents.
I mean, and maybe the point you're making is that this is the problem with substantive due process rights to begin with, but it seems like it's certainly a results-oriented approach to define it narrowly enough so that you can take it outside of the heartland of something that's been recognized in our history and tradition.
Your Honor, while I see your concern, this framing isn't taking it out of that, but it's rather recognizing that the issue that is before the court today is one that has to balance both parental rights, but also recognizing access to a specific medical procedure. That here framing it as a parent's right to access reasonably banned pediatric gender-affirming care recognizes the two different competing interests and aligns with this court's precedent in recognizing that states are afforded a wide amount of discretion to pass regulations when it comes to regulating public health, safety, welfare, and also in areas of medical uncertainty. Federal courts that have considered the precise issue before the court today, specifically the 6th, 7th, and 11th Circuit, have all agreed that the proper way to to frame the right at issue today is a variation of a parental right to access pediatric gender-affirming care. Now, moving to the second step of the substantive due process analysis is determining whether that right is deeply rooted in this nation's history and tradition. And as Your Honor mentioned, while there is a deep-rooted history of parental rights recognized by our Constitution in this country, there's also established precedent that this court has granted states wide discretion to be able to regulate public health and safety. Specifically in Gonzalez, this court held that states have wide discretion to pass legislation in areas of scientific and medical uncertainty.
Was that an executive decision or a legislative one?
It was a legislative decision, Your Honor, where it's the statute that was passed by the state legislature there specifically dealt with prohibiting partial birth abortion because of the competing uncertainty regarding that specific medical treatment.
So how much evidence do we have to have historically before it's considered sound? I mean, at what point would it be sufficient for the state to then back away and allow parents to make those decisions for themselves?
Your Honor, Respondent is not asking the court to make a decision today about exactly how much scientific evidence or research is needed in order to be able to make that type of decision. Rather, the fact that there is competing medical information, interests, and there's a lack of medical consensus speaks to the fact that this is a decision that is best left for the states to be able to engage in thorough policy fact-finding, to be able to obtain the guidance of medical experts and to have their opinion, for them to be able to determine what is the best way to regulate that, because it can be so conflicting, and it is not something that is this court should grant deference to a state's ability to be able to do that.
If a parent had the capacity to demonstrate, to prove to a court, to our fact finder, that a child's actual health or life was in jeopardy for failure to receive this treatment, would they be able to assert a justification defense to this ordinance?
Based on the facts that we have here today, Your Honor, and based on this court's precedent, here in the state of Hamilton, they wouldn't, Your Honor. And opposing counsel drew the line that parental rights can be limited in situations of life or death, but that's an incomplete picture because it's not just about life or death. This court's decision in Parham, relying solely on that justification overlooks the settled limitations on parental rights, where in Parham, the medical treatment itself was...
Let's step back from parental rights. Does an individual, regardless of, let's assume they're an adult, do they have a fundamental right to protect their own life, to take those steps which are designed and calculated to protect their own life as a matter of due process?
As a matter of due process, Your Honor, framing the right that broadly is something that wouldn't align with this court's precedent. Looking specifically at Dobbs and Glucksberg.
I'm asking you, like, as a matter of due process, like, can citizens violate the law in our history and tradition, otherwise violate the law in the interest of protecting their own life?
The individual or the state, Your Honor? I apologize.
Can an individual assert the defense of justification? And in other words, is that an inherent right of a citizen?
Your Honor, potentially, if a state was to pass a law that explicitly went against something, for example, like really established medical care, whether it be vaccines, then potentially, Your Honor. But here is recognizing how this court's precedent works is that it doesn't view substantive due process cases as this broader right to be able to have individual private decision-making or as broadly as that, but rather focuses on the very narrow framing as narrow as the medical treatment itself. This court has been reluctant to recognize rights not explicitly mentioned in the Constitution in the due process case for a very long time. And specifically looking at this court's history and tradition, even in Prince v. Jacobson, this court recognized that parental rights can be infringed upon when a parent's practices potentially endangers a child's health and welfare. Here, respondents recognize that there is competing evidence. While there are some short-term risks that children can face by not being able to access gender-affirming care, there is also incredibly competing medical evidence that demonstrates potentially long-term fatal both physical and psychological consequences. Here, looking specifically to Section 101 of the findings in the statute, the state of Hamilton recognized that minors living with gender dysphoria, while they can experience significant distress, and they recognize that implication, the state of Hamilton also recognized that no medications or treatment have specifically been approved by the FDA to treat gender dysphoria. The World Professional Association of Transgender Health only endorsed this treatment about a decade ago, which speaks to its novelness and that it is not deeply rooted in this nation's history and tradition.
Well, why is that? Is it considered safe for adults then and not children?
Because as my co-counsel stated, with minors there are different implications that don't exist for adults. A minor who accesses pediatric gender-affirming care may or may not have already gone through puberty depending on the age, versus an adult has already gone through puberty and has the ability to make, or the maturity and the ability to make decisions that are going to be significantly more long-lasting.
So would this not be valid, this statute not be valid if the child was beyond the age of puberty? Say if they reached puberty before they became 18?
Right.
No, Your Honor, because the way that the state of Hamilton defined the specific statute was focused on minors, which is under the age of 18. Here, in looking at, when no fundamental right is at stake, this court has to analyze the law at issue under rational basis, which under that analysis, the state has to be able to rationally relate its statute to a compelling interest. First here, this court has recognized that a compelling interest for states is regulating the health and safety of children. It has also recognized the right of upholding the dignity of the medical professional in Glucksburg as a compelling state interest. Here, the state of Hamilton specifically identified the purpose of the statute overarchingly is to protect the health and well-being of minors. The state of Hamilton identified specific medical risks that it recognized while there are some short-term considerations to consider of those risks that minors could be subject to. At the same time, fact-finding revealed that hormone therapy and surgeries can have irreversible, permanent effects. And the state of Hamilton took it a step further and didn't just focus on the medical consequences or complications that it had to balance, but it also found that there was abuse to minors in the state of Hamilton. Specifically in Section 101J, the state of Hamilton identified, quote, that healthcare providers in Hamilton perform surgeries on minors because of financial incentives, not necessarily because it's in the minor's best interest. Here, the state of Hamilton very reasonably identified many different associated risks for minors and drafted the statute in a narrow way that only restricts access to 3 types of medical procedures.
Is the fact that the legislature finds that particular practitioners are abusing the scope of practice a basis for limiting the scope of practice? I mean, it seems to me that would be a legislative finding that would support punishment for abuse of the scope of practice, not the abolition of that scope. In other words, if it was okay to do something, finding that some people had done it when they weren't supposed to doesn't change whether it was okay to do the thing.
Your Honor, I respectfully disagree, because that finding speaks to the fact that Hamilton's ultimate concern was really protecting the health and well-being of minors. The purpose of the statute isn't drafted or implemented in a way that is punishing medical providers or punishing specific individuals, but rather is limited in a way that only bans 3 types of medical treatments for individuals who are diagnosed with gender dysphoria. The state of Hamilton included many exceptions, like precocious puberty, as your justice earlier mentioned, congenital defects, and other things. And so the fact that there are many different exceptions, that therapy and other treatments are allowed, but only those 3 medical procedures, demonstrate that the purpose of the statute is to protect minors because of how novel and uncertain and unknown the long-term effects of pediatric gender-affirming care. Had it been written in a way that was meant to punish, then that would completely change the analysis.
Well, why do the accepted minors why don't they need those same protections as their peers?
Your Honor, I see that my time is almost up. If I may briefly answer your question and then
Go
conclude.
ahead.
Your Honor, those minors do, whether all minors deserve protection, I will agree on that, Your Honor. But at the end of the day is that here the state of Hamilton reasonably acted in a way to make a tough policy determination of what is the best way to be able to protect minors right now. Based on the findings that are currently available, this court should grant deference to that because it was a very thoughtful, narrow process of drafting a statute that is going to protect minors. Should the facts change in the future, then that could be different. But for the foregoing reasons, we respectfully ask this court to uphold the lower court's decision and find that there is no violation of the 14th Amendment. Thank you.
Thank you. Petitioner, you reserved, I believe, 2 minutes.
Chief Justice, Your Honors, on rebuttal, I just have 2 brief points. First, respondent tried to base their argument on the fact that transgender minors here are still able to receive therapy treatments as a reason for why the statute here is still valid. But that does not negate the fact that this still is a subsect of group that is not able to receive puberty blockers or gender-affirming hormones simply based because of their sexual identity. And I will point this court to its decision in 1985 in Claiborne, where this court said that sexual identity does not allow a differential in treatment. Second, respondents claim that this is novel science that has not been studied, but research on gender-affirming care has been around for more than 10 years, and all medical associations are approving of this care. As my co-counsel stated, not only here across the country in the United States, but abroad in Europe as well, and by the World Health Organization, proving that this medication and medical procedures are safe for minors, and it's a proper decision to make with their doctors and parents. Therefore, for these reasons I have stated and the reasons my co-counsel have stated, we ask this court to reverse the decision of the 12th Circuit. Thank you.
Thank you. All right, the case is submitted, and congratulations. Great job. Do we go back first?
This time I will ask you all to remain seated while I walk the judges to the
Thank you.
At this time, the judges are going to retire to the jury room to the floor.